I'm sorry, sir. This check is drawn against insufficient funds.
Ma'am, here is the return check. It bounced.
Welcome, everyone. Today, we're going to talk about what happens when a borrower does not pay a loan and how our company handles that situation properly and legally. If you have no background in financing, law, or collections, do not worry. This session is designed especially for beginners. By the end of this session, you should be able to answer these questions clearly. What is a loan? What is collateral or security? What does default mean? When can our company take property? And when is our company not allowed to take property? Before we talk about enforcement or repossession, we first need to understand what kind of loan we are dealing with. Not all loans are the same, and not all loans have security in the same way. Let us start with that. First, let us talk about unsecured loans. An unsecured loan is a loan where no specific property is promised as collateral. This means the borrower promises to pay, but no particular asset is set aside for us to take if the borrower does not pay. The most common example of an unsecured loan is a loan backed only by post-dated checks. Here is a simple scenario. A borrower issues post-dated checks for monthly payments. One of the checks bounces. In this situation, our company may demand payment. Our company may send notices. Our company may file a legal case. However, there is no specific asset that we can immediately take. Checks are payment tools. They are not property that can be repossessed. This is very important to remember. Unsecured loans rely on the borrower's promise and legal remedies, not on taking property. If there is no specific asset, the loan is unsecured. Now that we understand unsecured loans, let us move on to secured loans. A secured loan is a loan where the borrower promises specific property as security. This means that if the borrower does not pay, our company may enforce rights over that property. However, this can only happen by following the proper process. There are different kinds of security, and it is important to understand each one. First is security over real property. Real property means land or buildings. These are properties that cannot be moved. Examples include a residential house and lot, condominium unit, a commercial building, a warehouse, or vacant land. For example, a borrower takes a loan worth 10 million pesos and uses a house and lot as security. In this case, the property does not move. Enforcement is usually done through foreclosure, not repossession. The rules for real property are different from the rules for movable property. Next is security over personal property. Personal property means things you can move and physically touch. Examples include cars, dump trucks, motorcycles, construction equipment, machinery, inventory, or goods. For example, our company lends 2 million pesos so the borrower can buy a dump truck. The dump truck is the security. This is where repossession may apply. However, strict rules must be followed. The dump truck cannot be taken immediately after one missed payment. Security interest in personal property. Sometimes the security is not just the physical item itself, but a legal right over it. This is called a security interest. Security interest can cover tangible property, such as equipment, vehicles, inventory, or tools. They can also cover intangible property, such as accounts receivable, contract rights, or project receivables. For example, a company borrows money and gives its delivery trucks and its accounts receivable as security. These rights usually need to be registered. Enforcement follows special rules. Checks versus property. At this point, it is important to clear up a very common mistake. Checks are not collateral in the same way property is. This distinction matters because the type of loan determines what our company is allowed to do. For unsecured loans, our company may demand payment, collect, or file a lawsuit. For secured loans, our company may demand payment, accelerate the loan, and possibly enforce against property. But this can only happen after the proper stages are completed. If these are confused, enforcement can quickly become illegal. Let us simplify everything so far. Some loans are unsecured and backed only by promises and checks. Some loans are secured and backed by property. Property can be land, vehicles, equipment, or even legal rights. The type of security controls what actions are allowed. Now that we understand the type of loan, we can move on to the enforcement process. Let's discuss the enforcement process. Enforcement does not happen all at once. It happens in stages. Taking property is the last step, not the first. Phase 1. Loan creation. In the first phase, the loan is released. The borrower is paying. No one is in trouble. Even if the loan is secured, our company cannot enforce anything at this stage. Next comes registration or annotation. This step is applicable only for secured loans. Registration protects our company's priority. It does not give permission to enforce. Think of it as reserving a place, not using it yet. Let's discuss default and acceleration. Default means the borrower failed to follow the loan agreement. However, default alone does not allow repossession. Before repossession can happen, the loan must be accelerated. Acceleration means the entire remaining loan becomes due at once. Only after default, proper staging, valid demand, and internal approval can enforcement happen. Once property is taken, our company becomes responsible for it. The property must be kept safe and properly documented. If the property is sold, the sale must be fair and transparent. Any excess money from the sale must be returned to the borrower. Closing the case. Enforcement is not finished until records are properly closed. Registrations must be updated and files must be completed. As we end this session, remember this. Our company does not succeed by moving fast. Our company succeeds by moving correctly. Every loan tells a story. At the start, it is a story of trust. Later, it may become a story of responsibility. When a borrower pays on time, the story is simple. When a borrower does not pay, the story becomes more serious. That is when our actions matter most. The way we collect, the way we enforce, and the way we handle property reflect who we are as a company. Process is not there to slow us down. Process is there to protect everyone involved. When we follow the steps, we protect our company. We protect our borrowers. And we protect ourselves. When we skip steps, we create risk. Not just legal risk, but reputational risk and personal risk. Good enforcement is not loud. It is not aggressive. It is calm, documented, and defensible. If enforcement ever feels rushed, emotional, or confusing, that is a sign to stop and review the process. In our company, doing things the right way is not optional. It is how we build trust. It is how we stay compliant. And it is how we protect our future. Thank you.